right, good morning. We'll go ahead and get started. My name is Caitlin Wildoner. I am an attorney here in the St. Augustine area of Florida. I handle Social Security disability cases throughout the United States. This is a federal administrative practice area. And today I want to talk to you about how to file a Social Security request for reconsideration. If you have filed an application for Social Security disability benefits and it was denied, this is for you. You will want to know how to file a Social Security request for reconsideration. Today, we're going to talk about first some of the common reasons behind SSDI and SSI denials. We'll talk about how you can file a request for reconsideration. We'll talk about what Social Security will do once you file that appeal, also known as a request for reconsideration. And we'll finally talk about how an attorney can help you with your Social Security disability claim. A little bit about me. I am the founding attorney of Beacon Disability, PLLC. Again, our office is based in St. Johns County, Florida. I exclusively practice federal administrative disability law, which allows me to assist clients in all 50 states in agency-level Social Security disability and supplemental security income matters. Before we get into this, I do want to emphasize that today's webinar does not provide any type of legal advice. I am a lawyer. If you have questions, feel free to reach out to me directly. But because I don't know all the nuances of your potential situation, this webinar is meant to be a broad overview of the process, not legal advice. Again, if you would like legal advice, you have questions, I will put my contact information on the last slide of the webinar. So feel free to reach out to me if you've got any questions at all, okay? All right, so getting into it, I always like to start these webinars with a quick overview of the 5-step evaluation process. This is because a lot of times people don't understand how the process works, and it is very confusing. Even after explaining the 5-step process, it doesn't always totally, answer everybody's questions. But the first step when Social Security gets that application for disability benefits, they're looking to see, number one, are you engaging in substantial gainful activity? That means, are you working more than 20 hours a week? Are you earning more than $1,350 gross in a month? Generally speaking, if you are hitting either of those, you will be found to be engaging in substantial gainful activity. And Social Security won't take that application any further. They'll stop it there. They'll say you're engaging in substantial gainful activity and you can't be found disabled. It's important to note that while that 20-hour-a-week rule and the $1,350 a month in gross earnings is generally what Social Security is looking for, there are nuances to that. Much like anything dealing with disability, there are nuances and certain rules may apply to your situation that don't apply to most situations, as everybody's situation is unique. If you are not engaging in substantial gainful activity, Social Security moves to step 2, which is, do you have any severe medically determinable impairments? If you don't, the evaluation stops there. Social Security says you can't be disabled because you don't have any severe impairments. If you do have at least one severe medically determinable impairment, it can be a physical impairment or a mental impairment, then it will move to step 3, and they will look to see whether you meet one of the listings in their Blue Book. There are 14 chapters in the Blue Book, ranging from musculoskeletal disorders to mental health disorders to immune disorders to cancers. They will look and evaluate, do you meet any of the listings? If yes, then your claim evaluation stops there. But instead of a denial like we got at the other two, we'll get an approval. If you meet or equal a listing, you get approved at step 3. If you don't meet or equal a listing, Social Security will move to step 4. Before they move to step 4, there's kind of a step 3.5 almost, where they will assign you a residual functional capacity. That RFC is based largely physical, but it does also include mental impairments. And they will evaluate what they think you are capable of doing based on the medical records. Can you lift up to 20 pounds occasionally and 10 pounds frequently? Can you stand for 4 hours, 6 hours, 8 hours? Can you, postural limitations, climb ladders, ropes, and scaffolds, kneel, bend, crouch, crawl, stoop? So they will kind of evaluate at step 3.5 that RFC. And then they move to step 4 and they say, okay, the individual has this RFC. Can they go back to their past work that they've done? If they can, Again, claim stops there. You're not disabled. You can go back to your past work based on the RFC they've created for you. If you cannot go back to your past work, then Social Security moves to step 5 and they look at, all right, you can go back to your past work. Is there any work that exists in the national economy that you can do? If so, not disabled. If not, then you'll get an approval. So that's the general overview of the 5-step evaluation process. Again, there are nuances within it. Not every case fits nice and neatly inside these little boxes. So if you do have specific questions about your situation, feel free to reach out. If you have an attorney already, this is something that they are well versed in, more likely than not. This is the backbone of the Social Security evaluation process. And this is what we as attorneys often look at to evaluate the claims that are in front of us. We evaluate claims just the way judges do. We just often come to different conclusions. All right. So common reasons for disability denials. I think it's the most common reason is not being disabled according to the agency's rules. That denial applies to both SSDI and SSI claims. You're not disabled according to their rules. They've looked at your medical records and they think that it's not significant enough to reach a finding of disabled. The other common reasons are one for each program. So there's the 2 different programs, SSDI, which requires that you have worked and paid into the system, and SSI, which is income and asset restricted. So the common reasons for those denials with those specific programs fit into those extra requirements. For SSDI, one of the common reasons that we see is you don't have enough quarters of coverage. We'll get into that in a few minutes, but that is one of the common reasons that we see for SSDI denials is that you are not insured for Social Security disability benefits. Doesn't have anything to do with health insurance. SSI, a common reason for denial we'll see is if you have too many assets or you have too much income coming into the house. As I mentioned, SSI is income and asset restricted. So if you have too much income coming in, if you are married and your spouse brings in too much money, or if you have too many assets, and we'll get into this in a few minutes too, a common too many assets restriction that I see is in a married couple, and they both have, a newer model car, 2010 to earlier. That is often enough to push out of that SSI eligibility. And we see that denial unfortunately happen a lot with stay-at-home moms and now dads who don't qualify for SSDI because they don't have enough quarters of coverage, but they don't qualify for SSI either because there's too many assets and too much income coming into the house. All right, so looking at it more specifically, the too many assets / too much income denial that we often see with SSI, as I mentioned, there are income and asset restrictions. The asset restrictions, if you are a single individual, you cannot have more than $2,000 in assets. And if you are married, that amount bumps up to $3,000. That threshold does not include the home you live in and the land it is on. It does not include one vehicle that's used for transportation. As I mentioned a few seconds ago, if you are married and your spouse has a vehicle and you have a vehicle, that's 2 vehicles. Even though they're both used for transportation, that's 2. That's not just 1. So 1 vehicle used for transportation. It doesn't include any household goods or personal effects. Does not include any life insurance policies that have a combined face value of $1,500 or less. Does not include burial plots for you or your family. Doesn't include burial funds of up to $1,500 for you and your spouse. It doesn't include property that you or your spouse use in a trade or a business. Does not include money that's set aside under a PASS account, which is a plan to achieve self-support. And it does not include, this is a big one, up to $100,000 in an Achieving a Better Life experience or an ABLE account that's established through the state ABLE program. Okay, so there are very significant and stringent asset restrictions, but as you can see, there are some things that don't count towards that asset threshold. Okay, in addition to the assets, there's also those income restrictions. There are too many rules for us to go into right now. A lot of differences regarding earned income versus unearned income. I put the URL here that kind of explains those rules so you can look at it. To even cover it right now would probably take a half an hour in and of itself. And there's just so many differences, nuances, that it's not something that we can cover in a general webinar like this. But if you do have questions, what I would encourage you to do is to go to that website that's there and or call your local Social Security office. They are versed in this. They should know income restrictions. They've got the calculators that they should be able to do. Okay. All right, as I mentioned too, the SSDI denial that we often see is that you don't have enough quarters of coverage. So you have disability insured status if you have earned at least 20 quarters of coverage in the last 10 years. So basically, if you call in, you might hear us say, have you worked 5 of the last 10 years? That's kind of how we summarize it. As you'll learn, that's not totally the bright line rule, but generally speaking, if you have worked 5 of the last 10 years, you should qualify for SSDI as long as you've been paying in to Social Security during those 5 of the last 10 years. And if you haven't worked 5 of the last 10 years, then we kind of work a little bit more to understand whether or not you might have enough coverage for SSDI benefits. But that's one of the first questions I will ask. You can earn up to 4 quarters of coverage a year. You cannot earn more than that. And for 2022, for every $1,510 that you earn, you get a quarter of coverage. So once you've earned, and I'm not going to try to do off the cuff math, but I think it's about $6,040 for 2022. So let's say once you hit 6,500 in earnings, you will have covered your quarters for the year. The quarters of coverage does not mean you have to have a paycheck in each quarter of the year. It just means that you have to have put in enough money. You have to have earned enough. And for 2022, for every $1,510 you earn a quarter of coverage up to 4 quarters. Okay. Exceptions for that 5 of the last 10 years of insured status do apply under age 31 and certain other cases. Again, one of the first questions we'll ask, have you worked 5 of the last 10 years? If yes, great, we move on. If not, then we kind of dig in to try to see if there is one of those exceptions that would apply that might help you qualify for SSDI benefits. All right. Not disabled according to the rules. This is a very common denial, and this is the one that we can help with. Social Security, they do use the Blue Book of Listings, as I alluded to before. They have a Blue Book for adults, and they have one for children. And then they also will create that RFC for you. On children claims, they don't necessarily create an RFC, but what they do is they look at 6 different domains of childhood functioning and see whether the child has marked limitations in at least 2 of those 6 or extreme limitations in 1 of those 6. Because this is not a webinar specific to children SSI cases, we're not going to get into that, but that is not on this PowerPoint slide, but it is relevant. So again, not disabled according to their rules. This is a very, very common denial, and this is what we can often help with. So some fast facts about the initial claim denials. When you get the initial claim denied, a lot of clients we're starting to see now have their access online to their My SSA account. We as a law firm do not have access to that. We have no idea what you can see on that end, but it's my understanding based on talking to clients and potential clients that there might be like a status bar that shows kind of how far along the process is. And then once it's denied, if you check, it will show you that a decision has been made and it's unfavorable. I can't speak to exactly what it will say because, again, I don't have access to that. But you as a number holder, as a Social Security number holder, as an applicant for disability benefits, you are the one that will have access to that. If you don't have your My SSA account, not to worry. They do also mail a decision letter to the address that they have on file. These decision letters are form letters. There's not a whole lot of information in it. What does change from letter to letter are, hopefully anyways, the providers that Social Security has requested and received records from. That will be on the page. The other thing is the conditions that you have applied for. Those should be listed on the denial page. And occasionally you'll get kind of a little bit of a purview into what they're thinking as far as, you're not disabled according to our rules, or we think that you can go back to work as a housekeeper, or we think that, you can't go back to work as a housekeeper, but you can make adjustment to other work. So that page doesn't have a whole lot of details, and it is a form letter, but it does provide just a little tiny bit of insight as to what's going on. You have 60 days to file an appeal from the date of that initial denial. So again, for the initial denial appeal, it's called a request for reconsideration. Okay, you have 60 days to file that appeal, that request for reconsideration from the date of denial. Important. If you are disabled and unable to work, and Social Security says you are not disabled according to their rules, you can appeal. You don't have to take their word for it. If you are disabled, if your doctor says you are disabled, you don't need to take their initial word for it. Okay. However, medical evidence is key. Just because you say you're disabled does not mean Social Security will be able to find you're disabled. Also, just because your doctor put in the chart, this individual is disabled, doesn't mean anything. Social Security needs to know why the doctor said that. So medical evidence is key. What limitations do you have that are preventing you from working? That is what Social Security needs to know. All right. How to file a request for reconsideration. There's 3 ways you can do it. Right now, there's really only 2. You can do it online. Make sure, I always emphasize this, and I feel like I can't emphasize it enough. Make sure if you are filing an online appeal that you are on ssa.gov. Don't put your information into any other website. It'll ask for your name, your social, your date of birth. It asks for a lot of personal information. Make sure before you put that information in that you are on ssa.gov. Don't Google request for reconsideration and then hit the first thing that pops up. You can search ssa.gov request for reconsideration. Alternatively, you can file via the Postal Service, okay? There's 2 forms that you'll need to do that. There's the form SSA 561, which is the request for reconsideration. And then there's the SSA 3441, which is a disability report, which will explain where you are. The third option, currently not an option due to COVID-19 and the office closures, but you can file it in person. When the local offices and the field offices are open, you can sometimes file it in person. However, most people opt to file online or via those written papers or with an attorney. All right, so looking at the request for reconsideration, this is the SSA 561. This is a request for reconsideration. You will put your name, your social, your claim number. The claim number is on the denial letter. In the state of Florida, we have recently, well, not so recently, it's been a couple years now, started seeing the claim number. It used to be the same as your social, but we have started seeing that they've changed that, which I am actually quite happy about. So if there is a claim number that's different from your social on any of the paperwork that you received, especially that denial, make sure you put that in there. After you put that identifying information in, you'll want to put down the issue being appealed, okay? If you filed for disability, Social Security came back, said you don't meet our rules, you're not disabled according to our rules, that the issue is medical. The issue is you are appealing the fact that you are disabled. Then a brief reason why you disagree with the denial. This is not a place for you to write a dissertation on why you think you're disabled. Generally speaking, I keep it very short and sweet. But yes, you can include a couple of reasons here. I am disabled and unable to work. Something like that is sufficient. Okay. And then you'll go down and do contact information. You want to put your information with your signature, your mailing address, phone number, and the date. Okay. If you have an attorney, that information will be on the right side. Generally speaking, if you have an attorney, the attorney is probably the one filing this for you anyways. All right, here's the other form that you submit with that request for reconsideration. It's the disability report appeal. You'll start out by putting in your information. Section 2, it has contacts. It's the name of someone who's not your doctor, but who Social Security can reach out to who knows about your conditions. A friend, a relative, usually this will be a spouse, an adult child who lives with you or who comes over often to help. So that's whose information you'll want to put in here. And what will happen with this information is Social Security will sometimes reach out to them and ask them to fill out a third-party function report, which is a questionnaire that Social Security sends to your third party listed and ask them information about your day-to-day functioning and your activity level. Okay. Also included in this form is a list of any new conditions or any change in conditions. You'll want to list all of those out. If you have new conditions that have been diagnosed, list when it started, who diagnosed it, when they diagnosed it, maybe even what test was done to diagnose it, if a certain test was done. If you have a change in conditions, if you're getting better or you're getting worse in certain things, list that out, including when it started. For example, if you had knee surgery and let's say you had surgery on your left knee, well, your left knee might be getting better if you're doing PT for it, but you might be starting to have problems with your right knee because of your over reliance on it. So it's okay to say my left knee has gotten a little bit better because I'm doing physical therapy. However, it's not back to what it was before. And also my right knee is really starting to become a problem. Okay. And then in this form, you will also include updated medical treatment, updated provider names, location, visit dates, very important. This is what the page looks like for provider information. As you'll see, you'll put the name of the facility or the office, and as well as the name of the provider. So if you go see Doctors R Us and Dr. Smith treated you, you'll put that information there. You will also put in Dr. Smith's phone number, address, and then, like I said, the dates of treatment. Okay. If it is an outpatient clinic or an office, you will only need to put visits there. When did you first see them? When did you most recently see them? That's the last visit. And do you have any future appointments scheduled? Similarly, if it's a hospital, did you go to the emergency room there? When did you first go? When did you most recently go? Did you have any overnight stays in the hospital? When were you first in? When did you get discharged? When were you most recently in? When did you get discharged? Okay. Any medical conditions that are treated or evaluated by that provider, you'll put in there. Any new treatment that you received from the provider, you will put in there. If the provider has done any testing on you, you will also include that here. Certain things you'll see they'll want the body part of. So if you had a biopsy taken, they'll want you to list that body part. If you had imaging done, they'll want you to list that body part. If it was multiple, you can put multiple. You can also put multiple on this page, and then on page 10 in the remarks, you'll see, okay, provider 4, or here we are on provider 1. So provider 1 conducted a CT of my brain on March 3rd, and then they did a MRI of the brain on March 13th, and then I had an X-ray of my knee done. You can list it out. If you have multiple, you can do that on the remarks section. So that way Social Security knows they need to get all the records. Okay. Additional information that will be on that form: current medication, including the name of the medication, who prescribed it, why you take it, and whether you have any side effects. You'll also want to include whether there has been a change in your activities. For example, if when you last filled out the paperwork sent to you by Social Security, you were able to get up and move around and do dishes, that has changed for whatever reason, include that. Say, I can no longer do the dishes because when I stand for more than 45 seconds, my sciatica acts up, whatever the reason may be. You will also want to include any changes or updates to your work or your education. That's important for Social Security to know. In addition to the 561, the 3441, you will also want to send in an SSA 827, which is an authorization to disclose medical information. That will allow Social Security to request and receive your updated medical records. Okay, so you've submitted all that. What happens next? Social Security requests those updated medical records. Your claim will get assigned to a new adjudicator and will undergo medical review. Social Security will also send out new questionnaires to you and or your third party. This is, again, so they know what's going on with you. What's your day-to-day life like? How you doing? How you feeling? What can you do? What can't you do? They might send you for a new consultative exam. It depends on what your treatment looks like, depends on what they're looking for and what they need. So they might send you for a new one. This might be your first consultative exam. It might be your second or your third, depending on what all you have going on. Sometimes Social Security will send you for a physical and a mental consultative exam on the initial application, and then they do it again on reconsideration. So you go to a total of 4 consultative exams. Sometimes they don't send you to any. Sometimes they send you to some on the initial application, none on reconsideration. Sometimes that's reversed. They won't send you to any on initial, but they will on recon. It just depends. Once Social Security has amassed all of that evidence again for the second time, it will undergo another medical review and another determination. All right, how can an attorney help you? So what we do is we will review your documents for accuracy and completeness. We can discuss with you what Social Security is looking for in their requested forms. Again, the questionnaires that they send out, we can't fill it out for you. We don't know what you do. We need your help. We can discuss with you what Social Security is looking for in those forms. We work with you to provide relevant updates to Social Security throughout your claim, and the reverse. If we get an update from Social Security, we share that with you. We provide guidance on what correspondence from Social Security actually means. We file any necessary appeals. We review your medical records and discuss them with you. If you have to go to a hearing, we prepare you for that hearing. And we, again, if you have to go to a hearing, question you and any relevant witnesses during the hearing. Okay, so there's a lot that we can do, but I always say this too, it's important to realize that we need your help. You are the one that is going through this tough time. And so we need your help in understanding, number one, what are you going through? What is a day like for you? And number two, updates on your medical treatment. You can't hire an attorney and then ghost and then expect us to know what's going on with you medically. You've got to keep us updated. And most of our clients do an excellent job of that. And that really does help us help you. Okay. So as promised, here's our contact information. Feel free to give us a call. You can give us a call, send us an email. As I mentioned before, we do help federal administrative practice area, Social Security from the initial level through the appeals council. With each appeal, we kind of review the case and evaluate to see, is it something that we can take to the next step or not? Importantly, different attorneys may have different opinions. So just because, we or someone else say, no, we can't take this any further, doesn't mean it's not going to go any further. It just means that's not the office to take it any further for you. So we do help agency level claims, initial application, reconsideration, hearing stage, appeals council. We do not handle any federal appeals. Unfortunately, it's just not something that we do at this time. So that's our phone number, 866-803-7734. You can email us at contact@beacondisability.com. And again, our main office is in St. Johns County, Florida, but we do help clients throughout the United States. So I appreciate your time today. I appreciate you paying attention. If you have questions, feel free to reach out. Happy to answer any questions I can. Thank you so much. Take care.